Welcome to the Back of the Basics Employment Law webinars. I'm Patricia Gonzalez and I will be your host. I'm an employment lawyer at Parley McLaws, and for the past 10 years, I've been helping employers and employees resolve various problems that can arise during an employment relationship. I have created this series of webinars to teach you some basic employment law principles to help you identify when it is time to pick up the phone and give an employment lawyer a call. Now, before I begin, I want to remind you that these webinars are not intended to provide legal advice. If you have an employment-related issue or problem, please give me or an employment lawyer a call to obtain legal advice. Today, I want to talk to you about employment contracts, what they are, why they are important, and why you need an experienced employment lawyer to review or draft them for you. One thing you need to know is that the employment relationship is a contractual relationship. An employer and an employee enter into an agreement where the employer agrees to pay an employee wages in exchange for work, and the employee agrees to perform the work as requested by the employer in exchange for wages. This type of agreement is known as an employment contract. An employment contract can be verbal, written, or a combination of verbal and written. The employment contract, through its terms, will state out the obligations of each party. For example, the contract may state that the employee agrees to work Monday to Friday and that the employer agrees to give the employee a company vehicle for his or her use. In addition to the terms of the contract, employment relationships in Alberta are also governed by the common law. That is the law that has been developed by past judicial decisions, and employment legislation, such as the Employment Standards Code and the Alberta Human Rights Act, to name a few. However, the general rule is that an employer and an employee are bound by the terms of their contract. In addition, an employer and an employee can contract out of the common law in their employment contract. But if the employment contract is silent on certain aspects of the employment relationship, for example, how much notice the employer is required to give the employee to terminate the employment contract, the common law will apply. Depending on the circumstances, sometimes an employer or an employee may not want the common law to apply, because it can result in greater obligations or vulnerabilities than the party may want. Here at Parley McLaws, we highly recommend that employers use written employment contracts that have been drafted by experienced employment lawyers for their employment relationships. We also recommend that employees have an experienced employment lawyer review any employment agreement before they sign, so that they are aware of what common law rights they may be giving up or obligations they are accepting. So why is it important to enter into a written employment agreement? First of all, a written employment agreement is easier to prove if a dispute arises regarding the terms of the agreement. The last thing anyone wants in a legal dispute is to be in a he said, she said situation. A written employment agreement also allows the parties to set out clear and defined expectations. For example, employers can set how much notice or pay in lieu of notice it will provide to an employee at the time of dismissal, or that an employee cannot solicit clients for a period of time after the end of the employment relationship. Meanwhile, employees will want a contract to state explicitly how any bonus or commissions will be calculated and paid. Meanwhile, it is very important to have the employment agreement drafted by an experienced employment lawyer, because if a dispute arises between an employee and employer, the terms of the employment agreement will be scrutinized very closely by the courts, and if those terms are not properly drafted, the terms may not be enforced by the court. This is an outcome that you want to avoid. You may also need to make sure that the terms of an employment agreement comply with any applicable employment legislation. Now, once you have a written employment agreement drafted by an experienced employment lawyer, you will want to ensure that you do not inadvertently make that employment agreement unenforceable. An employment contract is like any other contract, and it needs three things to be valid. First, there must be an offer. Second, there must be an acceptance. And third, there must be consideration, which is the benefit that each party gets or expects to get from the contract. As previously stated, an employer will offer a person employment, and that person will accept the offer of employment, and the consideration is that the person will do work in exchange for payment by the employer. Now, what sometimes happens in the rush of excitement in forming the employment relationship, the employer provides the employee with verbal terms of employment, which the employee accepts, and then the employee starts to work immediately. Then on the first day or a few days after, the employer provides the employee with a written employment agreement, which the employee signs. Then years pass, and eventually the relationship breaks down, only for the employee to say that there was never any consideration for the employment agreement, which typically blindsides the employer. In that case scenario, a valid and binding verbal contract was formed. Then, when the employer provided the written employment agreement with the full terms and conditions, this is viewed by the courts as a new agreement that requires fresh consideration, because under the law, continued employment is not enough. The courts will say something more was needed and will hold that written employment agreement as not binding. So if I can leave you with one thing today, that is, whatever you do, if you spent the money on getting a written employment agreement that has been drafted by an experienced employment lawyer, do not let an employee start working before the employment agreement is signed. Put that on a sticky note in front of your computer so that you do not forget. Trust me, you will thank me for it. I look forward to talking to you all next month. If you have any questions whatsoever or want me to talk about a specific employment law topic, please do not hesitate to give me a call or email me. Until then, take care.